everyone. Welcome to Navigating Estate Planning with a Cancer Diagnosis with our wonderful speaker, Christine Brown Murphy, Esquire. I just wanted to share a little bit about Christine. It's my pleasure to introduce her. She is a partner at Zacharia Brown, a boutique law firm dedicated to helping individuals and families navigating estate planning and long-term care planning and asset protection. Their firm specializes in creating strong foundational estate plans that can safeguard assets and life savings as individuals move through the different stages of life. Christine brings extensive expertise in asset protection, planning, Medicaid and veterans benefits, eligibility, estate planning, and estate administration. She is a trusted advisor to many families, ensuring they understand their options and make informed decisions for their future. In addition to her legal practice, Christine is a well-respected speaker and educator, frequently presenting on elder law and estate planning topics. She lives in Peters Township with her husband and two children. Please join me in welcoming Christine Brown.
Thank you,
Welcome.
Jen. I'm so happy to be here speaking to this group of fine people this evening. I really do want to make sure that, the time we have together, that we make it as valuable as possible. So Melissa here on the screen, one that's waving right there, the real cute one, she's going to be monitoring any questions you might have. Melissa, do you want to kind of explain to them how they can, if they have a question, what they can do, and how we can make sure we make this go as efficiently as possible for everyone?
Yeah, it's great to be here. I'm actually on the board at Cancer Bridges, so I'm really excited to share Christine with you tonight. And thank you, Jen, for having us. I'll be with you the whole time. We're going to try to fit everyone's question. And so along the way, if you have something on your mind, feel free to toss it in the chat box there. I'll watch it and I'll make sure we grab Christine at the end to get your question answered.
Okay, wonderful. All right, so let's get to work. So as an attorney, unfortunately, I have to do the really fun, unfun technical stuff first. And I always have to give a disclaimer because a lot of what we are talking about this evening, we're going to talk in somewhat of a general sense. Obviously, I haven't had the pleasure of meeting many of you folks joining us this evening. So any of the information that you're hearing me discuss this evening is really in a general sense and does not constitute or create an attorney-client relationship. If you have an interest in working with me or working with my firm, at the end of this presentation, I will provide you with information and you can reach out and we can discuss creating that attorney-client relationship so that I can give you that really specific information that would apply to your circumstance. So one of the things I want to discuss, and I hesitate sometimes talking about my own personal journey, but I have a journey just like many of you may be going through, have gone through as well, and that surrounds my daughter Julia. 2 years ago, she was diagnosed with advanced thyroid cancer. It had metastasized to her lungs, very extensively cancer throughout her neck. And it was a shock, something that, just as a parent with a teenager who's sassy and likes to talk back, everything seemed fine, everything seemed great, until we found out she had a very extensive case of thyroid cancer. And, we sought treatment and we still are going through some ups and downs. We haven't yet completely received the all clear diagnoses yet, but we're hoping that will happen for us in June of 2025. Prayers and fingers crossed and all of those things we're looking for. But during our journey, Cancer Bridges has been an amazing support. As a parent to a teenager, it's not easy to find those places that the family can relate to, but also your teen can relate to. And Cancer Bridges just has had so many wonderful opportunities for us to come together as a family and as a cancer community to really support and lean on one another. It was astonishing to find out that just one evening when we were there for an event, There was a family that was also in the same school district as my family that their daughter was dealing with cancer as well. So you learn things just by being in a community of people that are going through similar things. So that is my story. Julia is 14 years old. And that's my son, Brendan, on the right-hand side there with her. And that was this spring going to homecoming, and she's doing great. Just praying for continued health and good reports from the doctors in June. And I hope and pray for the same for the rest of you. So let's get down to discussing what the point of this evening is. Estate planning and elder law is for everyone. Oftentimes, because we receive a diagnosis, it often prompts us to want to have these discussions and start doing this types of planning. But the reality is, regardless of what your situation is, it is critically important that we all have a plan. Okay. And this is something that you often don't want to wait until, you're really in crisis to sit down and think through, because it's really very, very important. So common misconceptions of when and why people should be doing planning is that it's only for people who are sick, or you have to have a certain amount of an estate plan, or it can be handled later, or that everything passes to my spouse anyway, right? And all of those things are not completely accurate. It's really important, if you have young children, that you do some kind of planning. And we'll get into that as we go through this discussion. You want to make sure that you are protecting not only yourself, but your spouse as well. If you have a spouse who relies on you for income, assets, things of that sort. You want to make sure that you get to have the right to make decisions about who's going to make important healthcare and financial decisions for you. And the reality is when you have a plan, it can really prevent and hopefully eliminate any kind of family conflict. Okay, so planning ahead will provide not only peace of mind for you, but peace of mind for your family. And it truly is a gift to think about these things, have these conversations with your family, and really have a plan that you can execute so everyone is on the same page. Okay? So why estate planning matters after a cancer diagnosis? Really, when it comes down to it, it's for peace of mind. Right? The statistics show that 82% of folks feel a significant amount of stress reduction when they complete their estate plan. They're more likely to feel confident about where their family's future will be. Okay. And again, the reduction, about 65% say there's a reduction in family conflict when a clear plan exists. Okay, so create certainty when there's so much uncertainty already surrounding us. Okay, and so let's move on to some of the things of what makes a really strong estate plan. All right, so these are really the essential type of documents you want to be looking at. And I'm going to tell you right now that they're not all created equal. Okay, everyone should have their own unique estate plan. And what Mary down the street has may not be what you exactly need. Every person's estate plan is unique and should be created based on your own personal circumstances. So let's talk about a last will and testament. That's really going to be a document that most of us are going to have, but should really be a basis of an estate plan. And I'll get into what exactly your will should look like. An elder-focused, durable power of attorney. Now, you're going to see the word elder in there. For many people who are not considered to be elderly, you're going to think, well, that doesn't apply to me. But the reality is an elder-focused estate plan really addresses what happens if you get sick and need certain levels of care, including nursing home care. It's a very comprehensive type of power of attorney. And in my opinion, regardless of age, everyone should have an elder-focused, durable power of attorney. You definitely want to consider a healthcare power of attorney as well as an advanced directives. And sometimes we look to trust, a revocable trust and an irrevocable trust. So let's talk about a healthcare power of attorney. Okay, so in Pennsylvania, what we are often doing is when we're looking to somebody's estate plan, we really do want to make sure that you have a healthcare power of attorney. That healthcare power of attorney is really going to be the foundation of decision making. Now, one thing I want to explain is that when you sign these estate planning documents, This does not take any decision-making power away from you. You are always the decision maker, okay? These documents are for in the event you may need assistance with decision making. You may have temporary incapacities, such as you're undergoing treatment, or you're having a surgical procedure and something arises, and your physicians and doctors and medical providers need to consult with the person you've appointed in these documents. These documents are tremendously important because not only are they going to allow you to choose who's going to make those decisions for you, but it allows you to really specify what types of treatment you want, what kind of pain management you want. And if it gets to the point of needing to make end-of-life decisions, you get to be the one who has identified what you do and do not want with respect to end-of-life decisions. Okay, so it's really important that you sit down and you think about this. And then when you are deciding, who am I going to choose to be this decision maker for me? You really do want to think about, is this person trustworthy? Are they composed under pressure? These can be very difficult times. You need to make sure that the person you are appointing can handle, the responsibility of weighing and evaluating information when deciding how your wishes should be carried out. Are they familiar with your values? I think that that's a really important one, right? You want to make sure that when somebody is being appointed to carry out these wishes for you, that they're not carrying out their wishes, they're carrying out your wishes. Okay. And it's important that they have the ability to gain information efficiently and quickly. Okay. And then once you get these documents executed, it's really important that you share this information. You should share it with your primary care physicians, with your oncology team. Absolutely share it with the person you've appointed, your agent or your healthcare proxy. You may also want to share it with immediate family members. When we have clients come into our office and they execute their documents, they often ask us to share executed copies with certain children or the people maybe they've appointed in their documents. And, that's certainly something you should consider doing. If you're getting treatment at UPMC or Allegheny Health Network, you're going to want to upload these documents to your chart so they're always accessible. We never want to be searching or looking for, where is my healthcare power of attorney? Where is my living will when something sudden arises? You want these things to be handy. And in fact, we would prefer for them to already be on file if that is possible. You absolutely want to keep original documents somewhere safe, always. Okay, always keep those somewhere safe. We always need to be able to access those original documents. So make sure that the person you've appointed has the ability to access those things. Now, when people come into our office and they're in crisis, it's often because they do not have this document here, a durable power of attorney. Okay. And oftentimes we always associate disability or the need to make decisions for an individual with people that are older. And I'm here to tell you, I've been practicing law now for 22, 23 years, and that is absolutely not the case. Things happen to people of all ages. And if you don't have a durable power of attorney, not only could your care and needs be compromised, but also that of your family and those that depend on you. Okay. So a durable power of attorney, in my opinion, is the most important document you can have. That document is going to appoint an individual you trust to be able to make financial decisions for you in the event you simply need assistance with that decision making or you are unable to make those decisions for yourself. If you have children at home and you need to make sure your mortgage is paid, your health insurance premiums are being covered, insurance claims are being handled properly, and you are unable to do those for yourself, a durable power of attorney is going to give someone you trust the ability to make those decisions for you. If you become incapacitated and you do not have these critically important documents, the only way your family members, those that you love, your spouse, People assume a spouse has an automatic right to make these decisions for you. They do not. You need to have a power of attorney that appoints your spouse to be your financial and healthcare decision maker. If you become incapacitated and you do not have those documents, on top of the emotional trauma, the emotional situation that they are facing and dealing with, they are now going to have to go through a guardianship. And a guardianship is a legal proceeding in which a court is going to decide who is going to make those decisions for you. Please do not make your family go through that. Number one, it's tremendously costly. It pales in comparison, the cost of a power of attorney pales in comparison to what a guardianship can cost. You're going to spend, thousands upon thousands of dollars hiring a law firm such as ours to have to go through the court proceeding of having a guardian appointed over you. And when a guardian is appointed over you, a guardianship takes away your rights. It takes away your civil liberties. So even though you may regain your capacity, that guardianship doesn't just automatically go away. We now have to go back and petition the court to have that guardianship removed. So a power of attorney is the way to protect yourself, to avoid your family having to go through a guardianship so that they can in fact make decisions for you. Okay. And often too, with the power of attorney, you may not be incapacitated, but maybe your treatment or the situation you're dealing with is just taking its toll on you, and you really can't manage the day-to-day things that you typically would otherwise be able to do for yourself. A durable power of attorney gives those people, again, the people that you trust most in this world, the ability to make those types of decisions for you. Typically, we're going to sit down and we're going to have a conversation about who can handle these responsibilities. Sometimes it's the same person, sometimes the same person for healthcare decisions, sometimes the same person for financial, sometimes the same person will be the executor, but maybe not. And it really does require a healthy conversation to decide who can step in and take on those responsibilities when necessary. All right, so let's talk about your will. Now, so many of us put a 100% emphasis on your will when we're talking about an estate plan. But I purposely address the powers of attorney first, because powers of attorney are for us. They protect you as an individual. They protect me as an individual, and they make sure the people I love the most in this world, or I trust the most in this world, can take care of the things that need to be taken care of for me as well as for my family. Okay, now let's talk about a will. So a lot of folks assume that a will controls everything, and that is just not the case. All right, so what does a will actually control? A will controls that personal property, the stuff that you own, individual accounts and assets without a named beneficiary or joint owner. That is what a will is going to control. So that means anything that you have a beneficiary designation on, life insurance, retirement accounts, things with a transfer on death designation, a POD, payable on death, those things are going to pass directly to the beneficiary. Those are not controlled by the will. Okay, so it's important for you to take a mental inventory right now and think, do I have assets that are going to pass by beneficiary, but I really actually intend for them to pass through my will? Joint ownership. This is one that always results in unintended beneficiaries or unintended consequences. And what I mean by that is, maybe in your will you say, I have 3 children and I want everything to go to my 3 children. But then you have a bank account and your bank account has one child's name on it. When you pass away, the ownership of that account is going to control who gets that money. So if you intend for that bank account to be divided in 3, but the fact is you have a joint owner on the account. So that account will not go in 3, but will rather pass and vest in the ownership of the surviving joint owner. Okay, so when we sit down with clients and we're talking about a will, these are the things we want to have a comprehensive understanding of, because oftentimes it's going to result in us needing to go back and update beneficiary designations, change ownership on assets to make sure that things actually pass how you intend for them to pass. And again, so I think it's really important to point out, again, your will only controls those things that are in just your name alone with no joint owner and no beneficiary designation. Okay? All right. So why do people consider a revocable living trust in Pennsylvania? So Pennsylvania, unlike Florida, where Zacharia Brown also practices law, we do a lot of revocable living trusts in Florida because the probate process in Florida is more cumbersome. It's more costly, and it's just more expensive. That's not necessarily the case at all in Pennsylvania. So what lends itself to a revocable living trust in Pennsylvania? If you have an estate that I'd say exceeds about $2 million, then maybe we want to consider a revocable living trust. If you have property in more than one state, so real estate, so if you have property in Pennsylvania and property in New York or some other state, we're going to want to consider a revocable living trust. If you have a blended family, if you have children from a prior marriage, and you want to ensure that your children from that prior marriage actually inherit something, and when you're surviving, if you pass away first, if you don't have a revocable living trust, your surviving spouse can simply just disinherit your children and have everything passed to their heirs. So a revocable living trust can prevent that from happening. It can ensure that upon your passing, that trust becomes irrevocable so that your surviving spouse can't change and remove your children as a beneficiary. So revocable living trust in Pennsylvania absolutely has its reasons. To simply prepare a revocable living trust just to avoid probate is often not the reason, okay? Probate in Pennsylvania is fairly inexpensive and often doesn't lend itself to needing to pay the extra cost of creating a revocable living trust, okay? All right, so let's talk about wills, all right, again. Now, this is something that in almost every will I create, we have to think about with families, all right? If you have a child or a grandchild who maybe has special needs, they're autistic or they have some kind of learning disability or physical disability, and we want to make sure that they can inherit assets from you, but not lose any sort of benefits that they may be entitled to. Government benefits like Medicaid, Social Security. You need to be very, very careful. You do not want to list them as a direct beneficiary. You want to create a special needs trust within your will or trust if we create a trust for you. This is called a testamentary trust, meaning that we put language in your will and these trusts only come into existence upon your passing. So it's not a trust that you have to fund or create now. It's only a trust that upon your passing comes into existence and is then funded with your assets. If you have a special needs child or a special needs grandchild, do not disinherit them. And also do not leave them money outright. We have to put special needs trust language in your will or trust so that they are properly provided for. Another type of testamentary trust is going to be for minor children. I have a 16 and 14-year-old. So my will says if my husband and I pass away prior to our children attaining the age of 30, their money, our inheritance, the money we're leaving to our children, will be held in trust. Again, this is only a trust that comes into existence if my husband and I die prior to my children attaining the age of 30. If we die after they attain the age of 30, then that trust does not come into existence and they get that money outright. But if we would pass away prior to them attaining the age of 30, their inheritance is going to go into a trust, and we have designated that the trustee, whom we have appointed within the will itself, is going to manage that money for their benefit, to use that money for their health, education, maintenance, and support. So if they need a vehicle to go to school, if they need their college tuition paid for, they want to go to trade school, if they're going to study abroad, if they want to start a business that's viable and a real opportunity, that trustee is to make those types of distributions on their behalf to supplement their lifestyle because mom and dad are no longer here. And you can structure these trusts however you want. They can be age-based. So some folks decide, well, I'm going to distribute everything, or a portion at 21, another amount at 25, the rest at 28. So these can be structured however you would like them to be structured. One of the most important parts about creating a testamentary trust, whether it be for a special needs child, whether it be for your minor children, or whether it be because your spouse is in a nursing home, which I'll get to next, is going to be deciding who is that trustee going to be. Because a trust is only as good as a trustee. If you appoint a trustee who just doesn't want to be bothered and is just going to bleed out that trust and give those kids anything and everything they want, then the trust really isn't functioning how you intended it to function. So you really do want to think about who will you appoint as the trustee and have a conversation with that individual. Now, certainly I have plenty of clients who appoint corporate financial trustees, and that can be part of the conversation as well. They will have an asset minimum. So depending on how much your children would be inheriting would dictate whether or not we consider a corporate trustee, but you can. And I think we've already talked about grandchildren. A lot of people think, well, I have kids, I'm not going to leave it to my grandchildren. Well, once we get into the conversation, usually people say, okay, I'm going to leave everything to my spouse and then to my children. And then my next question to you is going to be, well, what happens if one of your children passes away? Do you want that then to pass down to the grandchildren? And so the grandchildren often do become part of the conversation, part of the planning process, because most folks, and you don't have to be like most folks, your estate plan can be however you want it to be, but most folks end up choosing that if one of my children passes away and they have children of their own, I do want to see it go down to the grandchildren. And that's when we get into the testamentary trust language for grandchildren. Now, since we at Zacharia Brown are also elder law attorneys, and I'll get into that here shortly, our wills, when we have spouses who are dealing with a nursing home admission, our goal is to protect and preserve the assets for the spouse who is not in the nursing home. And that means we are repositioning assets. We are taking the assets from the spouse who is in the nursing home or who may need nursing home care, and we are putting those assets just into the name of the spouse who does not need nursing home care. At that point, we are going to update the will of the spouse who's not in the nursing home. So we are going to unsweetheart the sweetheart will, because most spouses, when they have a will and they create a will, they say everything passes to each other. And then when the last of us has died, then it goes to our kids. But the reality is when we have a spouse who goes into a nursing home, we are often looking to Medicaid to be the primary payer of that cost of care. And we want to protect those assets from passing back to that spouse who's in the nursing home. So essentially, we're doing one of two things. If my husband goes into a nursing home, I'm going to reposition our assets for my benefit. With a power of attorney, I'm going to utilize that power of attorney. I'm going to transition those assets over to my ownership, do some other things that Medicaid allows us to do to become eligible. And then I'm going to update my will. And my will is going to say that if I die first, these assets go into a special needs trust for the benefit of my husband. The reason we do that is because if we allow those assets to pass directly to my husband who is in a nursing home, he will lose his Medicaid eligibility and our assets will have to be spent down on the cost of his care. So to avoid that from happening, we pass those assets into a special needs trust and he can maintain his Medicaid eligibility. And when he passes away, our children will receive that money from that special needs trust. Okay. Now, this is a huge one that I see go wrong all the time. And I work with a lot of financial advisors, and we are always, always needing to go in and update beneficiary designations. And I'm telling all of you out there right now, if you have any minors as a beneficiary on any of your assets, that is a huge mistake. You do not want that to happen. Okay? Minors are not permitted to inherit assets. All right. So if you have your children, so for instance, I have a retirement account. If I had my children on as a beneficiary rather than the trust I established in my will, if I die and I just have my children who are minors listed as beneficiaries, they're going to be caught up in the court system. They're not going to have access to that money until a court appoints a guardian. And then on top of that, they're going to get that money at the age of 18 with no strings attached. You do not want to list your minor children as beneficiaries. You do not want to list your grandchildren who are under the age of 18 as beneficiaries. This is the importance of that trust planning that we need to do. You would rather have a will prepared, and within that will, we're creating that trust. And we want to direct the beneficiary designations into that trust. If you have your children, I had an estate just 2-3 years ago where the husband did not have a will and his kids were 16 and 17. No will. They were the beneficiaries of everything. It was caught up in the court system. The aunt had to pull from her own pocket for about a year to supplement these children's lifestyle until we got through the court system and a guardian was appointed. Don't do that to your family. Make sure you're getting your estate plan put in place. Make sure you're getting these trusts established for your children. And it might sound complicated, but I'm telling you, the majority of the time people come into my office and they say, oh my gosh, this was way simpler than I expected. And it's just about talking through the process. You need to get an estate plan put in place, especially if you have assets passing to minor children. It's critically important. Do not have assets passing to minors. So this is where I'm going to get into a little bit about the long-term care planning. So at Zacharia Brown, not only are we estate planning attorneys, but we are also elder law attorneys. And there's a big distinction, okay? As an elder law attorney, we focus on not only what happens to your assets when you pass away, but we're looking to devise a plan to preserve your assets during your lifetime. Okay. And we want to develop a plan to pay for future nursing home or in-home care. So a lot of folks are shocked to find out that Medicaid is the primary payer of nursing home care as well as in-home care. And I have clients who are millionaires and their spouses are on Medicaid, in-home or possibly if it's nursing home care. It's because we understand what the rules with respect to Medicaid eligibility require. Okay, so I want to say that again. Medicaid is the primary payer of nursing home care. Don't ever assume that Medicaid does not apply to you. It very well may, and if it doesn't right now, we as an elder law firm can work toward protecting your assets and making you eligible for Medicaid. Okay. Now, as elder law attorneys, we will devise a plan for veterans benefits, Medicaid eligibility, Medicare benefits, and other benefits that will help pay for long-term care. Nobody wants to go to a nursing home. So we always are looking to figure out ways to keep people in their home, but have benefits to help pay for that cost of care. It's tremendously expensive, okay? All elder law attorneys practice estate planning, but most estate planning attorneys do not practice elder law. And I can't emphasize the importance of that. And that's where your estate planning documents at a law firm like Zacharia Brown are really going to be the difference maker, because your documents are not only going to address what happens when you pass away, but they're going to have a very solid fundamental basis in what happens if you get sick and need nursing home care or long-term care. They will address those needs as well. The focus of general estate planning attorneys is really about what happens when you die. And it's just going to be a traditional will, powers of attorney, and trusts. Their goal are going to be minimize estate and inheritance taxes, which is obviously always a goal of ours as well as estate and elder law attorneys. But estate planning is for everyone. And I said this earlier, when people hear the word estate, they associate it with meaning millions of dollars. You can have a $50,000 estate. You can have a $10 million estate. Whatever is important to you, whatever you feel is important to plan for is something that should be addressed and taken seriously. So why we can't ignore the possibility of nursing home care is because these are the facts. In Pennsylvania, in 2025, the average cost of nursing home care is over $12,000 per month. That means you are looking at about $146,000 per year. This is not an exaggerated figure. This is not a figure that I made up. The Department of Human Services releases this figure every year. And every year, pretty much, it goes up. And this is what people can expect to pay if they require nursing home care. There's very little insurance that actually pays for nursing home care. Medicare will pay at most up to 100 days, but never does. So don't ever assume you will get that coverage. At the end of that period of time that Medicare will pay for some portion of your nursing home stay, basically the office, the nursing home admissions office comes and says, okay, write me a check for $12,000. Just had a client come in today. Her husband's moving to a nursing home and she had to pay before he's even there. She issued a check for $12,500 for the month of February. That's what she had to do. But guess what? We're going to have them eligible for Medicaid by March 1st. So she's going to pay for 1 month and we will have them eligible for Medicaid by March 1st because we understand what the law says and we're going to protect her assets. So according to the National Care Planning Council, the average stay in an assisted living facility is 29 months. So assisted living is a level down from a nursing home. Nursing home care is the highest level of care, which obviously is the most expensive. So according to the National Care Planning Council, the average cost of assisted living is about $6,000 a month. I think it's more than that, but this is what they're telling us. And so if we just go based on the average, we're looking at just assisted living for that 29 months to be $174,000. Okay. So if we look at what the average length of stay, or I should say, and then 59% of those folks who start in an assisted living facility end up in a nursing home, where those individuals then spend an additional 2.3 years. So if you are that person or your loved one is that person who follows that trajectory, you are looking at a big chunk out of your financial portfolio of over $507,000 that you would have to pay for long-term care. And if that's for you and your spouse, you're doubling that. And the reality is folks dealing with dementia and Parkinson's, they can spend a much longer period of time in these types of levels of care. So when we are talking about estate planning with an elder law focus, these are the types of things, I kind of touched on this a little bit already, but an elder law focused last will and testament. And that is when, again, we have a spouse who's in the nursing home. We don't want to leave our spouse who's in it. So we take all these steps, right? So my client who came in today, we're going to take all of these steps to reposition assets into her ownership. We're taking the house. She'll be the sole owner of it. Her retirement accounts, we're going to change the beneficiaries on those. Her husband will no longer be the beneficiary. The assets that we're going to be able to protect from her will be in just her name alone. But what happens if she passes away first? Because sometimes that does happen. What we don't want to have happen is that all of this work that we have done becomes undone because we didn't think into the future of what are all the possibilities that can go wrong. And that is where her will is going to not provide direct benefit to her husband. Instead, the money will go into a special needs trust, and possibly even a portion of it we're going to pass on to her children directly. Okay. Now, what I did not talk about yet is this little second line item here, which is this elder-focused irrevocable trust. If you have a concern about long-term care, you want to consider protecting your assets from nursing home exposure, an irrevocable trust may be something that is appropriate for you. This is not a revocable trust. A revocable trust does nothing to protect your assets from long-term care exposure. A revocable trust is purely for estate planning purposes. It provides no asset protection. If you have concerns about potential, need for nursing home care, we may want to consider a discussion about creating an irrevocable trust in which you transfer your assets to that irrevocable trust. When you create this type of irrevocable trust, if you need nursing home care in the future, the assets within that trust are completely exempt and they are protected from nursing home exposure. Okay, so this is something that we have a lot of literature on our website about. You can certainly now, I'll get to that. I'll have a slide to show you some of the publications we have on our website if you want to learn more about some of the things we discussed this evening. And then again, of course, an elder-focused durable power of attorney. Again, this is my second, third, fourth time mentioning an elder-focused durable power of attorney because by far it is the most important document you can have. And there will be distinct differences in an elder-focused power of attorney versus any general power of attorney. One of those things will be, does the power of attorney give your agent the ability to create an irrevocable trust for you? Because oftentimes we need to create an irrevocable trust because it's what makes sense. If we want to transfer real estate or appreciated assets, things you've had for a long time, an irrevocable trust is what makes financial sense with respect to how to protect those assets. And most powers of attorney are not going to have that language in it. So you do want to make sure you have an elder-focused power of attorney that will give your agent the ability to make unlimited gifts. Sometimes we want to make gifts if we're looking to become eligible for Medicaid, but it's deliberate. We understand, the consequence of making those gifts. It's part of a plan. Okay. We may want to create a veterans benefits trust, which is also an irrevocable trust. We need to make sure the power of attorney gives us that ability. We need to make sure we change beneficiaries on retirement accounts. We need to make sure the power of attorney gives us that authority. So, Melissa, I think we have some questions. I'm kind of getting to the end of my slide, so it might be a good
Yes.
point for us to answer some questions.
Yes, perfect. I did drop the website in the chat as well. I'm going to scroll back to our first question here. It is, I have future plans to move to Florida. Would you consider trust over a will?
Yes, yes. So Florida, and we practice law in Florida. We have offices in Florida as well. Florida. So I don't want to just blanketly say yes, but in Florida, because of how the probate process works and it's carried out, the probate process in Florida is more expensive. A judge does get involved. You have to go to court. So typically, we are leaning toward advising clients to creating a revocable trust if you are a resident of Florida. So yes, I would probably likely recommend a revocable living trust over a will in Florida.
Okay, great. The second question, what do you call the testamentary trust in your will?
It's called a testamentary trust. That's what it's called. So that means that the trust comes into existence. It's a will that it's a trust that you have created within the will itself. So anytime you say a testamentary trust, in the financial world, in the legal world, people will absolutely know what you're talking about, but it's called a testamentary trust.
Perfect. Third question, Jen, I think you were going to ask something after this. Third question is it possible just to add your adult child to your house deed and bank accounts without having to spend thousands on a lawyer? I can't really afford what I was quoted.
Yeah. So the unfortunate part is if you add your child to your house, they're going to pay thousands upon thousands of dollars in capital gains taxes. So what I mean by that, and this is a common misconception, okay, that folks are looking to avoid probate or reduce taxes. But when you add a child to the deed of your property and they don't live in that home, the IRS will look at that property as an investment property for your child. And that means that when they sell that home someday, they're going to pay a capital gains tax on that property. And that capital gains tax is going to be 20%. So I understand that sometimes engaging in the investment of estate planning can be expensive, but adding your child's name to your deed will cost thousands upon thousands of dollars more than an estate plan will ever cost.
Jen, do you want to pop in before I get this next question?
No, you're doing fine. I'm just going to keep recording if you ask the questions because I do think they're great questions and I think people will really be interested. But maybe
Yeah.
Christine, if you want to take your slides down.
Sure.
Yeah. Okay. So I think I just had two come in. Next one, Christine, is can you get long-term care insurance for a young adult diagnosed with cancer?
No, I mean, unlikely. So typically, anytime you have a diagnosis of some kind, that your long-term care insurance usually is not attainable. And you probably wouldn't need it for a young child, simply because they're a child and they could likely become eligible for Medicaid for the care that they might need. So before we get to the rest of the question, just so I can
Mhm.
show some of the publications, then I can take down my slides here. So we have, these are just a couple of publications that we actually have on the website for free for you to download, and we have plenty more. So if this is something that, if there's something that we discussed this evening that you might find additional attention, or some additional detail, please feel free to get onto our website, zachbrownlaw.com. And you can go ahead and download this stuff directly to your email. And if you feel that you want to request an appointment, you can do that right on the front page. Okay, and I guess I'll stop sharing. Is that what you'd like me to do?
Yeah, that's fine.
Okay, there we go.
Perfect. I added that publications link in there too. Last question that just came in. Can you designate a testamentary trust as a beneficiary on financial accounts?
That's exactly what we would do. So once we create the will, we then go back to your investment accounts and we identify the testamentary trust as the beneficiary. That's exactly what we would do. But you have to have that trust, you have to have the will in existence and the testamentary language within the will to be able to direct the beneficiary to the trust.
Great.
So were there any other questions?
Yeah, I think we got everybody in the chat. We still have
Okay.
a few more minutes if anybody has anything else they want to throw in. Had a great audience, Jen.
Yeah,
Yeah.
this has been fantastic, Christine. Just
Yes.
amazing information. And one thing that came to mind, I sometimes work with a lot of single moms. So, like you were talking about, in the event that someone has to go into a nursing home, how can they protect the assets for their minor child?
Well, so for a minor child, what you would do, so the law does recognize the transfer of assets. So the home, number one, you are permitted to transfer the resources to a child that's 21 years of age or younger. And then if, depending on the circumstance of the minor child, we would probably go to court and have a court declare them obviously as a guardian, or if they are a minor, to have a guardian appointed, and the law would recognize that they need to be supported. And so we'd probably then create a trust for the benefit of that minor child and be able to then transition those resources for that child's benefit.
Okay, thank you. There's
Sure.
another question here, Melissa. I don't know.
Yeah, dude. What is the average cost to set up an irrevocable trust?
So it depends. And I know that's the sound of every lawyer, but the reality is it does depend because, first of all, I don't know if you need one. It is not something that everybody engages in, okay, or is something that is necessary for everyone. Now, as part of an irrevocable trust, you also have to have the foundation of estate planning documents. You have to have your last wills and testament. You need to have your durable powers of attorney, and you need to have your healthcare powers of attorney. So all of those things are incorporated. In addition to just simply the creation of the irrevocable trust, we need to engage in funding that trust because you wouldn't believe the number of trusts we see come through the office with actually nothing in the trust. And so, what I mean by that is, as an example, your home. If you have your home and we want to title that and have your trust own it, we need to actually do a new deed to your property. So it's going to go from individual A and individual B to now individual and A, B's trust. Otherwise, the trust doesn't do anything. It doesn't offer that protection. If we're looking to also take assets and retitle those assets into the ownership of the trust, investments, life insurance, vacation property, we have to do all of that paperwork and ownership. So it really does simply depend on how convoluted, how involved is the process. What we do offer is when folks want to come into our office, we actually have our clients do some homework, but we also do homework as well. We have our clients complete a pretty comprehensive questionnaire. And we want to know all about your situation. Your children. Are we dealing with any children that have disabilities? What is your income? What expenses do you have? Do we have any debts and liabilities? Do we have any children with drug addiction? What are all of the things we need to take into consideration when we are doing this planning? And we also ask that if you, in fact, have any estate planning documents that presently exist, that you send those in as well, because we want to review them. We don't want to have to prepare new estate planning documents if the documents you have are sufficient. And so that allows us to then have a really solid first appointment discussion. And at the end of that first appointment, we can say what we need to do, what we don't need to do, and then we offer that quote as far as a fee goes. So it's not possible for me to really say what that fee will be until we have that opportunity to sit down, review everything, and decide what you in fact need.
And I think we have time. I have one more question that came in, Christine.
Yeah.
My late mother created an irrevocable trust with me as the beneficiary. What is its status now and with respect to me?
I'm not sure how to answer that question. Um, So I guess I'm not sure if she's still living. If she's still living, I guess we would have to find out if in fact you are a lifetime beneficiary or a remainder beneficiary. Typically, when we create irrevocable trust, the person creating the trust is what we call the lifetime beneficiary. So they are the benefactor, they receive the income for their lifetime. And then we identify remainder beneficiaries who receives what's remaining in the trust when that individual passes away. So I guess without me really seeing that trust or knowing the status, I unfortunately can't answer that question. Oh, she is deceased, he is
She's
saying.
deceased,
Okay.
yeah.
So it depends then on what she said. And typically, trusts dissolve upon the individual. So there's an administration process. And depending on if she had those assets passing outright, to her child, or if she had further trusts established within that trust for the benefit of her child. But typically, a trust is going to have to be resolved when the individual passes away. So it depends on if there's an attorney handling it, if there's been any kind of administration process, if the taxes have been paid. That's about generally what I'm able to offer on that.
Okay. And one more. Oh, okay. He said I still pay property tax in the name of the trust. So,
So you probably need to, without knowing much about it, I would say that it sounds like assets are still in the trust. If mom created the trust, then it probably needs to be administered. It probably needs to be dissolved. And depending on what mom said in that trust, those assets likely have to come out of that trust to make sure you're handling it appropriately.
all right. I think we'll make this next one our last one with to respect everyone's time here. Is there any way around the Medicaid 5-year look back period?
It depends. I mean, every day we beat the 5-year look back period. Medicaid is a very, very complex role. So it depends on the situation, especially if we have spouses. So for instance, the client that I said came in today, her husband's going to a nursing home tomorrow. They have assets well in excess of what Medicaid permits for them to be eligible, but we understand what the law says, and the 5-year rule doesn't even apply to her, and we will still be able to protect all of their assets. So the 5-year look back is really about people who are looking to just gift everything away. So depending on your circumstance, we may be able to attain Medicaid eligibility for you, very quickly, even if you have a substantial amount of assets. Every circumstance is going to be different. And we do have a couple of publications on our website that have a lot of really great information. But what I will tell you is when people start to worry about the cost of talking with an attorney, that is where they start to lose money, especially when they have a nursing home need. As I said earlier, the average cost of a nursing home is $12,000 a month. I will tell you right now that if you come in to see us, most of our clients don't pay for more than 1 or 2 months of nursing home care because we understand what that cost is, what the rules say and what the law says, and we're able to help shelter assets and protect them.
Wonderful. Jen, is there anything that we missed?